Can you switch? Can you switch the screen to show me and then Bernice after me? Okay. Good evening, everybody, and welcome to virtual Congregation Beth Yeshurun's special program this evening, honoring Ruth Bader Ginsburg, Justice Ruth Bader Ginsburg. We have a very special speaker tonight, Dr. Bernice Heilbron, who is herself a Harvard Law School graduate, also got a master in history from Harvard, and after a long and successful career as a lawyer, retired and then went back to school to get a PhD in American history at the University of Houston. She's been a very popular teacher at Beth Yeshurun's Jewish Learning Project, as well as the Melton program at the Jewish Community Center and on Yom Limud. And so without further ado, I'm going to turn the program over to Bernice Heilbron, who will now talk about the Ruth Bader Ginsburg, her career and her life.
Thank you very much, Rabbi Morgan, and welcome to all of you who are here online with us tonight. It's a great way to celebrate Chag HaMoed Sukkot. And I want to thank Rabbi Morgan for organizing this event and inviting me to speak. Years ago, I think it was in 2015, Rabbi Morgan and I talked about the possibility of teaching a course at Beth Yeshurun on the Jewish justices of the Supreme Court. It was a great opportunity for me to combine my experience as a lawyer with my teaching of history and my interest in keeping up with the court. And since then, I've really enjoyed teaching this course at Melton at the ERJCC. And I welcome this chance to talk with you about Ruth Bader Ginsburg, or as she was popularly known by her colleagues in the court, RBG. As you see from my heading here, RBG was known as the Thurgood Marshall of women's rights law. So she was very highly regarded within the legal community for her transformation of and the development of the rights of women under the law in this country. And we'll talk about in a few minutes how she systematically and strategically developed that law so as to ground it as carefully as possible in the Constitution of the United States, rather than in lesser grounds that might not be as permanent and enduring as the strategy that she created. In that respect, in many ways, she followed the model of Thurgood Marshall that he had achieved in connection with racial equality. And you probably are all familiar with Brown versus Board of Education that Thurgood Marshall argued before the Supreme Court. In this portrait of her at the Supreme Court, you see her with her hair pulled back demurely, her famous scarf. One of those scarves, by the way, was embroidered with the Hebrew word tzedek, justice. And one scarf, I don't know if it's that same scarf or another one, she recently donated to a museum in Tel Aviv. She had very warm relationships with a number of people in Israel. She had been there often, and one of the justices of the Israeli Supreme Court was a dear friend of hers. But in addition to being so highly regarded as a justice of the Supreme Court, the first Jewish woman on the court and the first Jew on the court since Abe Fortas resigned in 1969, she was also a cultural icon. And here is her, so we've flipped from this demure portrait to her being represented with a crown on her head, with the name Notorious RBG, which was a riff on a hip hop artist who she proudly said, like she herself was born and bred in Brooklyn. She loved this. You have to consider that this was at the age of 80 when she suddenly became the darling of millennials, to the point where with her rock star appeal, she appeared on men's t-shirts. Men would walk around with her face on their t-shirt, on tattoos, and everything else, from onesies that newborn babies received to, and here's a little anecdote that probably haven't heard before, but Temple Emmanuel in Dallas, in its preschool, named its beta fish, that was the school fish, the Ruth Beta Ginsburg fish. So truly, she was a rock star and known and beloved everywhere. This occurred right after her feisty, fierce bench dissent in the Shelby County case, and we'll talk about that when we talk about RBG's voice, her very strong, passionate, and effective voice on the court. But let's, Let me suggest some takeaways from tonight's talk that I hope I'll succeed in persuading you are takeaways. But as I mentioned, she modeled herself after Thurgood Marshall. She was his equivalent for the women's movement in the 1970s in the United States. She had experienced discrimination herself, and she worked to change the laws to provide for equal rights for women, and ultimately equal rights for women and men. And then when she sat on the court, her embrace of the rights of others widened to include all those who came before the court. So she started as a women's activist, and she then moved on to care passionately and very empathetically and compassionately for the rights of all people who came before her. And that was one of the aspects that truly distinguished her, perhaps from many other justices on the court. Perhaps similar to Brandeis, she started out as a people's advocate, and those 10 years of advocating on behalf of her clients carried over to the very careful attention she addressed when she was a justice on the Supreme Court. She addressed to the cases before her and the individuals who she knew the law and the legal decisions that she handed down would significantly impact their lives. So that was something she really brought to the court that distinguished her from a lot of other people. And before I leave this slide, I want to emphasize her words, which were equal citizenship stature. She was emphatic about equal rights. She did not want to hold on to the special categories of protective rights that women had enjoyed. She argued that she was looking for equal citizenship stature for women and men. And she argued that she was, and these are her words again, she wanted to eliminate sex role pigeonholing. And that by that she meant she wanted to reach to whatever the opportunity was that individuals sought to pursue on their own. Whatever unique opportunities those were, they didn't have to be the standard ones that the law provided for. And we'll see when we talk in particular about Stephen Wiesenfeld, one of the early cases that she argued before the Supreme Court, how she was looking for opportunities for men as well as women to pursue the path through life that they wanted to pursue rather than anyone had foreordained for them. Her life surely was not foreordained. She grew up in a working class neighborhood in Brooklyn, in a very modest family. There was never any expectation, as she said so often in her talks, there was never any expectation when she was growing up that she would be a lawyer or Supreme Court justice. People would often ask her that when she was speaking before groups or when school groups would come into her chamber. People would ask, did you always want to be a Supreme Court justice? And I'm sure it was with a big smile on her face that she said no, because the fact is there were hardly women who were practicing law when she was growing up, much less aspiring to be Supreme Court justices or to make the law for the women's movement, which she did. So with this in mind, I'm sorry, Jennifer, I'm having a hard time moving the script. There we go. Okay. Let me give you a roadmap for the talk as we go forward. First, we'll talk briefly about her childhood in Brooklyn. Then we'll move on to Cornell with her, her marrying Martin Ginsberg. They're both going to Fort Sill, Oklahoma, where he did his ROTC service for 2 years. Then they both moved on to Harvard Law School, where they were students. He graduated, they moved to Columbia, she moved to Columbia Law School, and we'll talk about that experience. Then we'll talk about the first job. Certainly a critical point, because had she gotten the job with a law firm that so many other classmates, the males in her class did, we might never be talking about her today. But she didn't get that position because women were not being hired by law firms. And that's why we do have this conversation today about her. And I would say that this next bullet here, the ACLU Women's Rights Project that she co-founded at Columbia in 1972, 1973, that's really what put her on the map. And that alone would have been enough for us to have this discussion this evening, because she argued cases before the Supreme Court, immensely successful in her advocacy in transforming the law of the land as to sex discrimination. From there, she had won a lot of public attention, and so we're going to talk briefly about President Carter appointing her to the DC Circuit Court of Appeals, which was the feeder court essentially to the Supreme Court. Then President Bill Clinton's appointing her as justice to the Supreme Court in 1993. We'll talk about her very famous decision in the VMI case, Virginia Military Institute, US v. Virginia, where she was the one who wrote the opinion on behalf of the court, which was really the culmination of her fight for equal rights for women. And then we'll talk about her dissents. She actually wrote in the course of her tenure on the court over 200 of the majority opinions. But from I'd say from the year 2000 forward, a lot of her dissensions that we remember her for are her fiery, her fierce dissents issued from the court. And we'll talk about those. Finally, we'll talk about her Judaism. Hopefully we'll have interspersed that from time to time in the other sections. Her legacy for us today, and then we'll have time for your questions. If you'll post any questions that you have in the chat box, Rabbi Steve Morgan will be attending to those. Thanks. So let's move on. Good. Okay. Her childhood. I mentioned that she grew up in Brooklyn. She was an only child. She had an older sister who died at 6 years of age of meningitis when RBG was just 14 months old. So she essentially grew up as an only child. She was very influenced by her mother and remembered her mother as her inspiration and the person for whom she performed so well in school in order to please her and to meet her expectations. She chose to honor and pay tribute to her mother on every occasion. And in her own words, let me share with you what her background was. My father came to the United States from Russia when he was 13, and apart from night school to learn English, he had no formal schooling in this country or in the other country. My mother was the sixth child to be born in her large family and the first one born in the USA. She was born 4 months after her parents arrived from Austria, and she was a very good student. She graduated high school at age 15 and then went immediately to work so that she could help support the eldest son, who was going to Cornell. In those days, the eldest son was the one on whom the most attention was lavished, and no one thought about sending girls to higher education. Well, you could see she grew up with this attitude at home that her mother had passed up her opportunity to go to Cornell, and this was going to be the destiny of her daughter of RBG. Another quote, a riddle that she often shared with people, with audiences, is this: what is the difference between a bookkeeper in New York's Garment District, which is what her mother was, and a Supreme Court justice? Just one generation. My mother's life and mine bear witness. Where else but America could that happen? So I would suggest that from that we learn that RBG treasured her Jewish immigrant background. She always shared these comments. She spoke to many audiences all around the country and beyond, and she loved to share these memories of her Jewish immigrant background, how great America was, that within one generation, one could travel from being a bookkeeper in the garment district to being a Supreme Court justice. Now, I want to share with you two stories briefly of the wisdom that her mother and her mother-in-law shared with her that she loved to share with audiences. First, her mother's comments. They were these first two bullets. First, be a lady. And that meant, as far as RBG explained it, that meant don't let anger or emotions get in the way. They're a waste of your energy. Just let them pass over you. And the second was be independent. Now that was unusual for mothers at that time, in that era, to recommend. By independent, what RBG understood was that she should be able to earn a living for herself. She grew up anticipating that she would be a high school history teacher. Now, the third bullet refers to some wisdom that Marty Ginsberg's mom shared with her. She and Marty were married in the home of Martin Ginsberg's parents. And just before the wedding ceremony, her mother-in-law-to-be called Ruth into her bedroom and said, "Would you like some advice, dear, as to how to build a good marriage?" And Ruth, of course, said yes. And Marty's mom said, "It helps to be a little deaf." And at that point, she handed to her a box of earplugs. Now, RBG, with a little bit of a snarky smile, would then add, when she shared this with audiences, she said, "I've always found this helpful, not only in my wonderful marriage of 60-some years, but also in every workplace I've ever been, including the Supreme Court of the United States." So take these away with you. I have found, as I put together this talk for tonight, that I found that this is such good advice. And I think that you might agree with me that there are many, many opportunities to put these lessons to good use. There was one more bit of advice that that I thought was particularly helpful that she shared, and that was from Marty's father, who she used to call Dad. When she was pregnant with her first child, she was going to start law school at Harvard Law School in a year. She was very worried about how she was going to take care of a toddler and manage Harvard Law School, especially the first year, which is so difficult. So listening to her concerns, Marty's dad told her, "You know, Ruth, if you decide not to go to law school, nobody will hold it against you. They will understand. But if this is really important to you, you can make it work." And this is a piece of advice that she always loved to share too, because that's exactly what she and Marty did. They hired a nanny from 8 to 4 every day, and that allowed RBG to successfully attend Harvard Law School. In fact, she made law review and was at the top of her class. And that bit of advice was something that she implemented all through her life. If whatever you want to do is something that you really want to do, then you can make it work. Okay, so her mother had, we'll stay with her in Brooklyn for a minute longer. Her mother had cervical cancer all through RBG's time in high school. RBG's practice was to come home at the end of the school day and sit with her mom while she did her homework. Her mom passed away the day before RBG's graduation. RBG was the valedictorian of her class. She stayed home instead of delivering her address so that she could sit Shiva with her father and the family. I think that's a comment of her Judaism at that point in her life to her. She had gone to Jewish summer camps where she was identified as the volunteer rabbi. One can just imagine, just as she excelled in everything else in life, she excelled in her Judaism as well. Okay, so she had a scholarship to Cornell. She went off to Cornell. And she fell in love there with the law as a tool to help people. When she worked for her constitutional law professor, that professor was involved with defending those who were being called before the McCarthy-era Red Scare loyalty boards at the time. RBG became quite enamored of the possibility of using law as a tool to help others. And it was at that point that she also thought that it could meet her need to be independent so that she could earn a living. And that's when she made the decision to go to law school. Also at the beginning of her time at Cornell, she met Marty Ginsberg. And in her own words, Marty was the first male who cared that she had a brain. They married upon her graduation. He was a year older, so he was already at Harvard Law School at that point. Their marriage had a lot to do with her success. She herself will explain that she would never have made it to the Supreme Court without his assistance. After her graduation, they married, as I mentioned, and then they did 2 years of military service at Fort Sills, Oklahoma, where Marty, who had been in ROTC, was able to satisfy his military service obligation. While there, RBG worked for Social Security at Fort Sills, and she had an early experience with sex discrimination in the federal civil service. She had been hired in as a GS5 category, and then she was denied that position when she told her supervisor that she was pregnant. She was demoted to a GS2, learned a lot about sex discrimination in the process, and it was during that year that their daughter Jane was born. It was a wonderful 2 years to be away, in part because Marty really learned how to cook. They had gotten a copy of Escoffier cookbook, a big fat French cookbook, and he learned early on, as I understand it from his mother as well as his wife, that he really ought to develop some cooking skills. And he worked his way as a chemistry major might have through that cookbook and learned how to cook very well. So after 2 years in Fort Sills, they go on to Harvard Law School. She's a first year, he's a second year student. That's where you have the stories about her being one of only 9 women in a class of 550 men. And Dean Irwin Griswold, who was dean of the law school at the time, had a tradition of inviting the women in the class to dinner at his home and asking each woman to please explain why she should have a seat that would otherwise have gone to a man. Again, another instance where she was hit in the face with the discrimination against women. In his 3rd year, Marty developed testicular cancer. And here again, we see Ruth rising to the occasion and through hard work, diligence, and brilliance, making everything work out. She herself was a 2nd-year law student. She would go to school during the day. She would arrange for Marty's classes to be covered by his friends who would bring her their notes at the end of the day. She would type his notes up and then
Bernice, you're muted. There you go.
Just as an FYI, Jennifer, I didn't do anything. So I don't know how that happened. I don't know if we can do, we can avoid that.
That was my fault. I was letting someone in the waiting room and it accidentally clicked on the wrong thing.
Oh, no problem. Thanks for letting me know. Great. Okay. So that's pretty much their experience at Harvard. Marty graduated and went to work for Weil Gotshal and Manges in New York. I'd like to take this as an aside, an opportunity to point out that he went to work for a Jewish firm. In those days, as I recall, they had Jewish firms and they had Christian firms in New York, and you knew which one to apply to. So he went to work as a tax lawyer. He became a very well-known and very successful tax lawyer and partner in Weil Gotshal. Ruth finished law school at Columbia. She made law review there just as she had at Harvard. This is really quite amazing. And she tied for the #1 spot in the class at Columbia. You might imagine with that kind of record that she would have had her choice of jobs, but of course that was not to be the case. No New York City firm would hire her. She had interned actually at Paul Weiss, a wonderful Jewish firm, during her summer, but they hired Pauline Murray, who was an extraordinary African-American woman and they wouldn't hire two women. So she didn't get that job. Not only was she a Jew and a woman, but most important, perhaps, as employers were concerned, she was a mother. So when Al Sachs, professor at Harvard Law School, contacted Justice Felix Frankfurter on the US Supreme Court, suggesting that he invite RBG to interview for clerkship, he declined. Now, Frankfurter, you might have expected, would have been one person to say yes. He had already hired William Coleman Jr. as an African-American clerk, so he broke the color line, but he drew the line when it came to women. He told his clerk, you know, how could we have a woman who's a mother here working in the office? I love to curse all the time. We couldn't have, I couldn't be cursing and have a mother around here, which really perplexed his law clerks because he never cursed, but that was his line. RBG did a lot better with her Columbia Law School professor, who secured her a federal district court clerkship by promising a guarantee and making a threat. That is, he promised Judge Edmund Palmieri of the Southern District Court in New York that if RBG did not work out, he had a man who could take her place. But if he did not give RBG a chance, he would never provide a clerk to him again. So with that threat and promise, Judge Edmund Palmieri allowed RBG to clerk for him. It worked out extremely well, and she spent 2 years there, but then she was in the same position again. There was no firm that was going to hire her, and there was no other court either that would take her for another clerkship. So she returned to Columbia Law School, and a project that took her to Sweden to learn Swedish and co-author a casebook on Swedish civil procedure. I understand it's still used to this day. Perhaps best of all, it exposed her to Swedish feminism and to another way of looking at life. That is, there was apparently no problems with daycare availability in Sweden, and there was a much more gender neutral approach to couples so that men and women pursued their opportunities regardless of their gender. And she learned from that and brought that back with her to this country. There are some jokes that are told about her expertise in civil procedure. She loved civil procedure. And when she returned to this country, that's what she taught at law school, at least for the first many years. I guess it was Justice Elena Kagan that said, whenever the Supreme Court had a really tough question on Swedish civil procedure, they would take it to RBG. So with that experience in mind, she then returned to this country, and unable to teach at Columbia, which had no women on the law school faculty, she got a job at Rutgers Law School in Newark. And the dean there offered her a lesser salary than the men got because she had a husband at home to support her. And so when RBG said, well, how about if you give me the salary you would give a bachelor? That did not win her any more money either. So again, you know, another experience that she had with sex discrimination. So she went on to a successful career teaching at Rutgers Law School. She was able to, thanks to her mother-in-law's billowing clothing lent to her, she was able to hide her pregnancy when in 1965, James was born, the miracle baby after the bout with testicular cancer. And that completed their family. In 1970, RBG earned tenure at Rutgers. Now, her students pushed her, her women students who were activists, who were involved in the women's movement at the time, pushed her to be interested herself in the question of women and the law. They asked her in 1969, shortly before she got tenure, they asked her to create a course about women and the law. As she tells the story, it took her about 1 month in the library to read all the cases that existed at the time. So that was apparently fewer cases than come down nowadays within 1 month. But 1 month, she was able to read all the cases. She put together a course on women in the law. And this really began her focus on women's need to win equality with men under the law. That plus she was getting referrals from the ACLU in New Jersey about women who were bringing complaints to the ACLU that they wanted to have help with. So she set up a clinical program, and she got her students. I mean, this is the way you get a crew to help you with your work, right? She got her students to do clinical work, to work with women who brought their problems with discrimination to the students for their assistance, and she learned from them as well. So she ultimately co-authored a case book on sex discrimination in the law, and she went on to continue to teach in this area. In 1972, the ACLU voted to set up a women's rights project, and they brought in RBG as a co-founder and director of that project. And that was based at Columbia. She was able to, at this point, move from Rutgers, New Jersey to Columbia, and she became the first tenured woman faculty at Columbia Law School. Her commitment to equality for women, let me use her own words to sum up her fight for equal rights for women. And I'll just read the underscored parts in the interest of time. But she said, "I was fortunate to be born at the right time and to be in the right place when the women's movement came alive. I had a legal education, and I could use that education to help move this movement for change, for allowing women to realize their full potential, help move that along. So it was that 10 years of my life that I devoted to litigating cases about, I don't say women's rights, I say the constitutional principle of the equal citizenship stature of men and women. I was tremendously fortunate to be able to participate in that movement for change." Well, she was fortunate. We're all fortunate that she was able to participate in that. You know, I think it could be that if she had gotten the job with Paul Weiss, as I mentioned at the outset, we would never have, she would never have gone down this path. But she was 37 years old at the time when her students first came to her and asked her to teach a course on women in the law. But she jumped right into it, and she used, as she said, this tool, the law, in order to make a difference. And let me move on to the next slide. I don't know, Jennifer, why I can't move. Can you move this?
No, I can't.
You can't?
No.
Why do you think that is? Oh, here, let's try this. There we go.
There you go.
Okay, thanks, great. I love it. You know, with a computer, there are always 3 different ways to get to the same end, right? So 1971, she provides the brief in the case before the Supreme Court. She doesn't argue the case, but she provides the brief that makes the difference and establishes the argument that the judges respond to. So let me clarify this. Sally Reed and her husband were divorced. The son at his father's place was killed by a shot from his dad's gun. Sally Reed was the first to file to administer her son's estate. He had died intestate, and her application to probate his estate was denied because under Idaho probate law, males must be preferred to females to administer an estate. Now, why was that? Well, the thought under Idaho probate law apparently was that men were in the business world and they would know how to do this, whereas women were at home and wouldn't have any idea how to do it. So in the event that it was a male versus a woman, the male must be preferred. So RBG wrote the brief, as I mentioned, for Sally Reed, arguing that this was a denial of equal protection under the 14th Amendment to the US Constitution. And the Supreme Court agreed. I think this was a unanimous decision. This was the first time the US Supreme Court struck down a sex-based law. They could not figure out why. That is, they didn't come up with a reason, but they struck it down. And this then became the law of the land, and we'll see it cited often. And RBG became known as the #1 Supreme Court of the US litigator for gender equality as a result of this. Now, this might be the first time I'm using the term gender. So just as an aside, she used to always talk about sex equality and discrimination against women. But one of her secretaries at the Women's Rights Project said to her once, you know, instead of sex, you should talk about gender. It helps to focus the mind. And so she made that switch, and I'll try to remember to do that as well. Okay, so around the same time that she was writing the brief in Reed versus Reed, Charles Moritz had a case that came before the 10th Circuit Court of Appeals and was looking for somebody to represent him in this case. You know, the story is that Marty was working in the dining room at home and RBG was working in the bedroom. Marty came in with the advance sheets, the sheets that explained the cases that were up on appeal, and said, you know, Ruth, I think this is something you'd really be interested in. At which point Ruth said, you know, Marty, I'm not interested in tax law. But okay, she read it anyway, and it turned out this was really the perfect case to move forward as a team, the two of them together. So here are the facts of the case. Charles Moritz was a traveling salesman who cared for his elderly mother. He had never married. He claimed a tax deduction for the expenses that he incurred in hiring babysitters when he was traveling, because he needed somebody to look in on her when he was away. And he put that on his tax return. He was audited, the IRS audited him, and they disallowed this expense because he wasn't a woman and he wasn't he wasn't married. A married man could have carried this. And the concept was there that the married man who was traveling surely had a wife at home, and she would need some help, or the wife, a woman, of course, would need some help with this. But an unmarried man, he just wasn't part of the statute. So Ruth and Marty took the case. They wrote the brief indicating that this was a denial of equal protection under the, let's see, so this was the IRS. So it was under the Fifth Amendment to the Constitution. Yes, it would have been equal protection under the Fifth Amendment because it was the IRS. And the court, since Reed versus Reed was decided while this was being considered, the 10th Circuit cited Reed by Reed and agreed that the Internal Revenue Service Code was a violation of equal protection under the law. So this was a big success for RBG, and it was the beginning of her strategy of bringing men's cases to the court. And this was a brilliant aspect of RBG's strategy to assure equal rights for women. That is, it was hard to persuade, it was hard to teach the judges on the court, who were all male, why is it that women's protections should be thrown aside in favor of equal rights? They thought their wives were getting good care at home, and it was wonderful for women to be able to choose whether they wanted to serve on a jury and to have all of these protections. After all, isn't that what Brandeis had fought for, and the reformers earlier in the century? They had fought for these protections for women. And here's this woman coming into court and asking that the protections be thrown out. So RBG recognized that if she goes into court seeking protections for men, very often the court would be more responsive. And we'll see that she did that when we look at the Stephen Weisenfeld case. I have this as a picture of Ruth at this point of RBG. And in her own words, she described herself as a flaming feminist litigator. And she was. Now, these were milestone gender equality cases that she put together as part of a strategic, incremental, and controversial approach to advance equality based on equal protection under the law. And this equal protection is really critical because she was always basing it on either the Fifth Amendment or the 14th Amendment, equal protection, which was a much more solid basis in the law than the right to privacy, which Roe versus Wade was based on, because nowhere in the Constitution does it say right to privacy. She was very careful to make sure her cases were based on equal protection. So we've talked briefly about Reed versus Reed and Charles E. Moritz versus Commissioner of IRS. I'm going to say a few words now about Frontiero versus Richardson, which was the first case that she argued herself before the court. And then a few words about the Weisenfeld case, in part because it resulted in a lifelong friendship, again, so telling of the way RBG worked in the law to create these kinds of long-term, eternal friendships. And then when we talk about her being on the US Supreme Court, we'll look at US versus Virginia, which really was the culmination of all of these gender equity cases. So let's turn for a minute to Frontiero versus Richardson. Sharon Frontiero was a lieutenant in the US Air Force who was denied health and housing benefits for her husband, Joseph Frontiero. So the argument here was that federal law required women members of the service to satisfy different standards for dependency benefits from men, and this violated Sharon Frontiero's constitutional right to due process. This was her first case that she argued before the court. She sought a decision based on sex as suspect classification. So again, harking back to Thurgood Marshall, who had succeeded in getting race designated as a suspect classification and thus having the highest burden of proof on the government to support it. She was trying for that too. She failed on getting sex as a suspect classification, but she did succeed in getting the court to understand that Sharon Frontiero was unjustly discriminated against as a woman, and that was struck down. So lest you feel that this woman was a quiet advocate before the court, I wanted to share with you the final line in her advocacy of this case before the Supreme Court, her first case that she argued. She ended her testimony, her argument, by saying, "I ask no favor for my sex. All I ask of our brethren is that they take their feet off our necks." So I thought that was really quite a pungent, feisty conclusion. Admittedly, she was quoting abolitionist Sarah Grimke. Still, I think she made quite an impression with that. So we'll move forward 2 years. This is the last of the cases before she goes on to the Supreme Court that we'll talk about. And this is the Stephen Weisenfeld case. Paula Weisenfeld was a teacher who died in childbirth. She had been the primary breadwinner. Her husband, Stephen Weisenfeld, as he said in his own words, played homemaker. So here we get to the, let's not pigeonhole people scenario. Stephen Weisenfeld wanted to stay home and to rely on Social Security benefits in order to raise their son. He was denied Social Security survivor benefits because he was male. Widowers had no benefits. The concept was that men would have been the primary breadwinner to start with, and they would continue to work. The court ruled, they held that Social Security rules denied to Weisenfeld, denied him due process under the Fifth Amendment, and RBG was able to win the case for him. Years later, Stephen Weisenfeld testified before the Senate Judiciary Committee on behalf of RBG's nomination. Even years after that, he called RBG to ask her to officiate at his second wedding, and his own son had RBG officiate at his wedding as well. So we have close to 10 years of RBG litigating cases, transforming the law on behalf of women and men, persuading legislatures to correct laws where it was statutes that needed correcting. She had become quite a public figure. When in 1980, President Jimmy Carter famously looked around the federal judiciary and said, "They all look like me, they're all white guys." He chose to change that situation, and he appointed RBG to the DC Circuit Court of Appeals. Now, this was a feeder court to the US Supreme Court. The other aspect of this, this appointment that we should keep in mind is that this is where her famous friendship with Antonin Scalia began. Scalia and RBG and Robert Bork sat on this court together. And here's where, maybe it pays to be a little deaf or not to let things irritate you in terms of differences of opinion. They became famously good friends, and that carried on then to her time on the Supreme Court as well. In 1993, Bill Clinton needed somebody to take the seat of Byron White, who left the court. He ultimately called RBG, met her, loved her at first sight. The two of them really hit it off. And with Marty Ginsberg being a tax lawyer, there was some assurance that their taxes were in good order. He walked RBG out into the Rose Garden and announced her nomination, which she accepted, bringing tears apparently to the president's eyes when she talked about her beloved mother. I should say she wasn't his first candidate at all. He had tried Governor Mario Cuomo, who was governor of New York. He tried Secretary of the Interior Bruce Babbitt. He tried Professor Larry Tribe at Harvard, and he brought Stephen Breyer down to interview him, but they did not hit it off. With RBG, he did. If anyone wants to talk about this further during questions, we can talk about Marty Ginsberg's role in making all this happen. Suffice it to say, the attitude in the Senate was quite different from today. And let me just briefly mention that it was Utah Senator Orrin Hatch, a Republican, who was head of the Senate Judiciary Committee at the time. When RBG announced during her testimony that she supported abortion, Senator Hatch said, well, I don't agree with her, but I'm going to vote for her anyway. And in fact, he got the entire Judiciary Committee to support her. It was an 18-0 vote. It was referred out to the Senate, and with a 96-3 vote in the Senate, she was accepted as the new justice of the U.S. Supreme Court. Now, keep in mind, she had had this fiery career with the ACLU Women's Project, and yet this apparently was not held against her at all. So she takes her seat on the Supreme Court, and 3 years later, the VMI case comes. Let me just say a few words about that case. The United States, and it's exciting in this case that it was the US that was bringing charges of gender inequality against the state of Virginia, because Virginia Military Institute was an all-male institution that would not admit women. The US had sued the state before on this matter. In response, Virginia set up a women's school that it considered separate but equal. The US did not consider that to be the case, and Clinton's Solicitor General proceeded with this lawsuit. Chief Justice Rehnquist, knowing how dear the issues here were to RBG, gave the decision to RBG to write for the court. You'll see it was a 7-1 opinion. Clarence Thomas recused himself because his son was a student at VMI. Justice Scalia was the one who dissented, and out of kindness to his dear friend RBG, he gave her a draft of his dissent well in advance so that she could address it fully in the opinion she wrote for the court. Well, the opinion she wrote for the court was, of course, based almost entirely on the precedent that she herself had established. So it was this really great way for her to tie a ribbon around all of those Supreme Court cases that she had argued herself that had made the law of the land such that you could not discriminate against women, as the state of Virginia was doing in this case. Now, there's a lot more to be said about that, but in the interest of time, let me move on and talk about with you for a few minutes the power of dissent. The first and second Jewish justices on the Supreme Court, Louis Brandeis and Benjamin Cardozo, believed in the power of a powerful dissent. As Cardozo said it, a dissenting justice speaks to the future. No one has to hope that's true, because they certainly weren't speaking to the court at this point, right? The court had made its decision. They had not been in the majority. They had not been able to persuade their fellow justices of their opinion, but they were able to take their opinion to the public and to have them recorded as a matter of law. RBG took this shared wisdom a giant step further. She reads her dissents from the bench wearing a collar that signals her intention. There's enormous courtroom drama, people will watch as the justices file into the courtroom to see what collar she is wearing on any given day, so that they can be alerted to whether this is going to be a day that she will issue a fiery dissent from the bench or not. And she may call for specific corrective action as well, and thus be able to address and resolve the problem that she identifies in her dissent. And that was the case of her dissent in the Lilly Ledbetter case in 2007. Because this was an interpretation of a statute and not a constitutional law problem, because it was a statute, her dissent from the bench was able to identify the problem for Congress to identify. Congress made it a priority. They corrected the errors that she identified in her fiery dissent, and it became a part of the presidential campaign discussion when Barack Obama was campaigning during his first presidential campaign. He committed himself to signing the legislation that Congress passed, and within 10 days of his taking office, the president signed what came to be called the Lilly Ledbetter Fair Pay Act in 2009. I don't think I want to take time to go through all of her arguments here, but let me just briefly summarize that this case where a woman working as on the floor of a factory and as a manager of Goodyear Tire was suing for unequal pay, that her pay was discriminatory based on her gender. The court gave a narrow interpretation to the statute of limits that was within the statute and said that she could not file for the pay that she hadn't received that was longer ago than the 180 days set forth in the statute. RBG contended that this failed to take into consideration the real world circumstances, as I think many of us can appreciate. When somebody is being discriminated against in connection with pay, they typically do not know what their male colleagues are earning. They don't want to have to sue their employer because they probably wouldn't keep their job. And any single paycheck, even the court would not want to see, because you don't want somebody coming in every 2 weeks to the court saying this pay was unequal. So with all of these issues in mind that RBG was very alert to because of her empathy with the kind of people like Lilly Ledbetter who were suffering from these inequities of the law, RBG was able to plead the case, and she pled it from the bench in a dissent that got so much publicity that the law was changed as she had suggested. Now, another case, of course, where she dissented was the one where she became famous as the Notorious RBG, and that was Shelby County versus Holder, and that was a voting rights ruling. Voting discrimination, she said from the bench, still exists. No one doubts that, but the court today terminates the remedy that proved to be best suited to block that discrimination, which was the Voting Rights Act of '65. And she announced from the bench that hubris is a fit word for today's demolition of the VRA. Throwing out pre-clearance when it has worked, that's pre-clearance of any kind of change in voting procedures, and continuing to work to stop discriminatory changes is, and this was her famous saying, it's like throwing away an umbrella during a rainstorm because you're not getting wet. RBG had this masterful use of language to really drive home with images what she wanted to say, and to say it in just a few words, but in a pithy, minimalist way that was very effective. In terms of the drama that this created, if you can picture the 9 justices on the court, the Chief Justice has just announced the decision, and she is sitting next to him or 2 seats over, and she is, as soon as he gives his decision for the majority, she's announcing her dissent, and she's using words like hubris and demolition, essentially telling the Chief Justice that he's all wrong, right? So that's what won her the attention of the millennial generation and so much love. Hobby Lobby stores was another place where she was fiercely opposed to the way the court looked at the case. Hobby Lobby was where a corporation was deemed to be able to express its religious disinclination to support contraceptives under the Affordable Care Act, and the court upheld that argument. Her point was that religious-based choices should not be imposed on employees who do not hold those beliefs. And in her pithy statement, in sum, your right to swing your arms ends just where the other man's nose begins. So clearly she's looking at this from the point of view of the women at the cash register and not from the owners of the store. Another case where she issued a pithy dissent, in this case joined by Sonia Sotomayor, was the Masterpiece Bake Shop. That was the Colorado baker who, when a gay couple came into the store to order a wedding cake be created for them, refused to create a wedding cake for the couple because he was opposed to gay marriage. His arguments was that he had protection for the free practice of his religion as guaranteed by the First Amendment, and also a freedom from enforced speech, which is how he designated the creation of a cake. The court, in fact, ruled on the basis of the fact that the discovery showed that Colorado Commission expressed hostility to religion. So the court did not even get to the First Amendment issues. They essentially threw out the case based on the fact that the Colorado Commission had ineptly handled the whole matter. RBG dissented, and I think this is so telling of her embrace of what she considers the need of each person in this country to be embraced by the we the people standard in the Constitution. She said the baker refused to provide a cake to a couple because they were gay, and that was wrong. And that's the basis on which she would have decided this case. And finally, let me mention Gamble versus US, just to show that sometimes these dissents create strange bedfellows. In this case, this was a double jeopardy case, under the dual sovereignty rule. That is, the fact that we are under the governance of state law and federal law, we can be prosecuted for the same crime twice, once by each of the authorities. And that's what happened in this case, where the person was convicted of possessing a firearm with a felony record, and he was sentenced to 2 separate prison sentences. His argument was that this was double jeopardy. We have a long tradition in this country of the dual sovereignty rule, which permits one to be tried in this manner for the same case. So this is the issue of stare decisis, of precedent, which is so prominent before the court today. As you can see, it was a 7-2 decision. 7 justices thought that precedent is more important than doing perhaps what was right for this person who faced double jeopardy. But RBG, together with Neil Gorsuch, said that it's wrong to prosecute twice for a single offense, and precedent be damned. We think that it's time for a change. Now I'm going to skip some other cases and just conclude with a few words about RBG and her Judaism. And I thought that perhaps the most telling testimony to her commitment to her Judaism was a picture of Rabbi Lauren Holtzblatt, her rabbi at Adas Israel, a conservative congregation in Washington, D.C., who presided over her funeral at the Supreme Court, and once again in the Capitol building. Rabbi Holtzblatt also doubled as a cantor. She started the ceremony by singing Psalm 23 in Hebrew. She concluded it by singing El Malay Rachamin in Hebrew. The entire ceremony lasted 18 minutes. I think that was telling. It was a beautiful, very traditional, I think, Jewish tribute to the beloved justice for whom Rabbi Holtzblatt's husband had served as a clerk. And I think it was very telling that RBG, who was meticulous in reviewing this kind of thing, I'm confident that she went over this with the rabbi beforehand. Correct me, Rabbi Morgan, if this never happens, but I think that that's something that RBG would have done. And I think the very traditional nature, and at the same time to have a woman conduct the funeral when she herself had been denied the opportunity to say Kaddish for her mother, was also very telling of RBG's Judaism. And I don't want to take the time to read her discussion in her own words of her Jewish identity, But let me emphasize three aspects that she constantly reiterated to people. One is that she had the word tzedek, tzedek, tirdov, justice, justice shall you pursue, on 3 walls of her chambers. She had a large silver mezuzah on the doorway at the entrance to her chambers that was a gift from the Shulamit School for Girls, a girls' yeshiva in Brooklyn, on her doorway. And she always talked about the symmetry of her occupation as a judge with her heritage as a Jew. And she did so not only to the American Jewish Committee and to the Holocaust Memorial Museum and to the Jewish Women's Archive, to Jewish audiences, but she also did so when she talked to non-Jewish audiences. And just by way of a very brief example, here's an excerpt from a speech that she gave to the District of Columbia Law School, where she concluded her speech by saying, in the words of the Talmudic sage Rabbi Tarfon, the day is short and the task is much, but the reward is great. So she was very out there with her representation of her Judaism, what it meant to her, and what she wanted to share with others. So let me wrap up with her legacy to us. I hope we can agree that she transformed gender law in the US, and that alone would have been enough reason for us to talk about her. But then she went on to pursue human rights for everyone. She mentored more than 100 Supreme Court clerks and became a beloved friend to many more. She created a legion of young people who support and will continue her work. As she used to advise people, bring a crew along with you. She was recognized for changing our world and creating opportunities that we enjoy today. When I see videos of her speaking at law schools, there are perhaps 1,000 who will come out at any given law school to hear her. Each one always recognizing that they would not be there, but for her standing up for gender equality, gender equity. She was the first Jew and the first woman to lie in state in the Capitol building after more than 200 years. And we can take pride in her accomplishments. Her advice provides us with a roadmap for our own lives, which is pursue your ideals, work for what you believe in, pick your battles, don't burn your bridges, know when to say no, be a little deaf, befriend without bias, and don't let differences interfere. And finally, know what you want to accomplish and you'll find a way. As Rabbi Steve Morgan said in his Yizkor service to the Yizkor sermon to the Museum Minyan, pursue your ideals to make a difference. And just for fun, you can't spell truth without Ruth. So that's it. Thank you for your patience, and I appreciate your listening to this. If you have any questions, I'm happy to take them at this time.
Thank you, Bernice, for a beautiful presentation. If anybody does have questions, you can put them in the chat box and we'll look at them over there. And I had some things that I thought about, but I forgot to write them down. So
that's okay.
Does anybody have any questions? Please feel free to write them in the chat box if you do.
Okay. Well, I can suggest if anybody wants to hear more about RBG, you can look at YouTube, just put in her name.
Yes.
She was very public about herself. I think that was part of creating a crew to continue her work. She got out there until perhaps just weeks before her passing to be interviewed. Often she was very slow in her responses. You could tell she was thinking. In fact, in a lovely comment about her, Justice Stephen Breyer said after her passing, he said, you know, I used to go and visit her in her office. Steve Breyer would say, Steve Breyer was one of my professors, so I always feel I particularly enjoy hearing his comments. But he'd say, you know, I talk and sometimes I think, but Ruth, she would think and think and think. That's the way she is, and you can see that yourself. You know, sometimes she's pretty fluent when you see her speaking in a Q&A session. There's a particularly fine one if you check the if you do a Google search for Harvard Law School, when Dean Martha Minow herself a Jewish law professor, interviewed her on the occasion of the 20th anniversary of RBG's term on the court. And it's a really lovely interview with lots of really beautiful questions from the students in the audience. That's one that I particularly recommend, is Martha Minnow's interview on the 20th anniversary. So that would have been 2013.
There was also an interview by her biographer on MSNBC, I think, which was pretty interesting. But one thing you might want to mention, one of the questions that came up in the box here was that when she was first nominated to the Supreme Court, some feminists did not think she was radical enough because she was not in favor of Roe v. Wade per se, right? Do you want to comment on that?
Yeah, I'd love to have a chance to talk further about that. One of the reasons Bill Clinton did not talk to her sooner is RBG and Marty Ginsberg both had talked to Daniel Patrick Moynihan, their home state senator, about putting forward Ruth's name. And he did. Daniel Patrick Moynihan went to Clinton. Clinton said, nope, the women are against her. And then Marty got on the phone. He called more than 100 women and got them to call their congressmen and try to make a difference. But why were women's groups against her? She had written something negative about Roe versus Wade. Initially, I thought it must have been soon after, Roe versus Wade was 1973 already. This is when she was just starting. But I think it was actually closer to 1993 when the Supreme Court chair was up for grabs, that she had written something that was published, and it was negative about Roe versus Wade. Now, it's not that she had any issue with abortion. She was solidly behind abortion. As I said, she even talked about that in her confirmation hearing. But she was against Harry Blackmun's using the right to privacy as the basis for it, because it's such a shallow, I hate to use the term shallow, but she thought it was the wrong, pardon me?
A thin, perhaps.
Yeah, and she also thought, she had herself made her, based her success on systematic incremental change. And she thought it would be much more successful to accomplish a change in abortion law on a similar basis. Instead, what Harry Blackmun did was he had Texas laws, I understand it, in front of him, which was apparently one of the most intrusive laws. And he struck that down, and as a result, he struck down every law in the country. Whereas if we had gone state by state, her feeling was we would have been much more successful, and we would have avoided the problem we have with Congress today, where we have created this target, right, on everyone's back. Either you're for abortion or you're not. Whereas she said if in 1973 we were more strategic, we would have built up a group, right? She was all for building up a crew to make things happen. We would have built up a people state by state who would have been supportive of abortion in their individual states. And we wouldn't have created this situation in Congress where it's all or nothing. So, but it was both the right to privacy, which is inherently weak. I think that was first cited in Griswold versus Connecticut, which was the contraceptive law, which prevented married couples in their own bedroom from using contraceptives, right? And I think that actually might have been in Arthur Goldberg, when Justice Goldberg was on the court, that right to privacy was the basis for that decision, which he sort of plucked from Brandeis in an unrelated matter. But it went from Griswold with the contraceptive issue to Harry Blackmun in Roe versus Wade. And it just was a particularly weak foundation compared to her own foundation on the 5th and the 14th equal protection argument. Does that answer your question?
Yeah, I think that was the main question. I think that what people were wanting to know about. So yeah, thank you very much, Bernice. This was a really terrific explanation of her life and her legacy, and also about her Jewish life. And as you said, there is a lot of information out there for people to watch. Interviews that she's done. There's two books out, or more. How many biographies are there now?
As far as I know, there's only one biography. You know, the Notorious RBG really doesn't qualify as a biography, I think, but it's
Oh,
a
okay.
great read.
Oh,
It's a
okay.
great read, and I recommend it highly. So there's the book, Ruth Bader Ginsburg, My Own Words. You know, she hired somebody to write her biography. It was a woman with whom she had worked in the 1970s on sex discrimination, who had come to her and asked if she could write it. And then the person just didn't write it. She said that, I want to wait until you've solidified your position on the court. And so the second book, that is RBG in Her Own Words, came out first rather than after. That's a wonderful resource, though. And you can get it actually from the public library in electronic form or an audiobook form, which you can also an e-audiobook, where the introduction is in her own words. That is, she recorded the introduction herself, so it's great to hear that. And the rest of it is somewhat in the form of a biography, but it's really her words about her life.
Mm-hmm. Did she write a textbook on gender laws, or she just taught the class?
She did. No, she co-published a sex discrimination casebook with a professor, I think at UC Berkeley.
And is that still available? Do you know? I imagine you can get it on Amazon, right?
I would think it's probably pretty much outdated unless she kept it current, and I have no idea.
Right. That's true. Yeah,
right.
It was long before a lot of the cases that she ended up ruling on.
Exactly.
Right. Okay.
Right.
Well, thank you again very much, and thank you everybody for participating in this program. And may we take her legacy forward and continue to promote equality for everyone.
Thank you. Thanks, Jennifer, for your help and for making all this possible.
Absolutely. Okay. Thank you, everyone, for joining us tonight.
Thank you, Rabbi Morgan.
Thank you.
Good night, everyone.